When a 28-year-old White House press secretary stood alone before the Supreme Court, most expected an apology, maybe even a tearful retreat. What no one expected was a constitutional masterclass that would leave the justices speechless. This wasn't just a legal battle. This was a moment that rewrote the rules of power, courage, and the First Amendment. And the woman behind it? She didn't flinch. She made history. What the public didn't know, what only a handful of NASA's highest-ranking officials and a select few in the White House understood, was that Apollo 11's mission carried far more significance than just winning the space race against the Soviets. Intelligence reports suggested the Russians had discovered something unusual on the far side of the moon during their unmanned lunar missions, something they were keeping secret even from their own cosmonauts. Neil had been briefed in a windowless room at the Pentagon 6 months earlier. The surveillance photographs showed what appeared to be unusual geometric formations, too regular to be natural, visible only from certain orbital trajectories. The briefing officer, a stern man from an agency whose name Neil was never told, had made it clear. Your primary mission remains the same. But if you find anything unusual, anything at all, you're to document it with the special equipment we're providing. The American people can't afford surprises. Miss Leavitt, Justice Barrett's voice rang out, crisp and cold as polished steel. This court finds your statements deeply concerning. Karoline didn't flinch. Around her, the gallery was filled with senators, journalists, law students, and more than a dozen cameras capturing every frame of what had been billed as a historic reprimand. Her name had trended for 72 hours straight. But nothing felt real now. You have 7 days to retract your statements and issue a formal apology, Barrett continued, tapping the gavel once for effect. Or we will refer this matter for criminal contempt. A wave of gasps rippled through the courtroom. Karoline slowly opened her folder, revealing a thick sheaf of papers marked with handwritten notes, court citations, and bookmarked pages. No one breathed. It wasn't defiance in her eyes. It was something far quieter and more dangerous, certainty. Justice Barrett, she said, her voice calm but firm, I respectfully disagree with your assessment. The silence deepened. She took a single step forward, not toward defiance but toward the edge of something bigger. Behind her, her legal team sat frozen. None of them had wanted her to go through with this. The apology statement had been drafted, reviewed, rehearsed. But Karoline had spent 3 nights reading everything she could find. Bridges v. California, Garrison v. Louisiana, Wood v. Georgia. She had not slept. She had not eaten much. But what she had found wasn't just case law. It was principle. Now she was here, standing not just for herself, but for the idea that truth, even uncomfortable truth, had a place in a democracy. I've prepared a 15-page legal response, she said, outlining why my comments, while pointed, are constitutionally protected under this court's own precedents. Several justices exchanged glances. Chief Justice Roberts leaned forward, intrigued. Barrett's eyes narrowed. Miss Leavitt, this proceeding is not a debate. With all due respect, Karoline replied, the moment we start punishing speech, it becomes exactly that. At 28, she was the youngest official ever summoned before the full Supreme Court. Most people in her place would have apologized, smiled, survived. Karoline Leavitt had chosen to argue. And what happened next would not just test her career, but the very limits of free speech in modern American democracy. Karoline drew a slow breath and placed the first page of her document on the lectern. Before the court proceeds, she said clearly, I ask permission to respond not as a press secretary, but as a citizen defending her constitutional rights. Justice Barrett's expression remained stern, but she gave a subtle nod. Proceed, but be brief. Karoline flipped to the first tabbed page. My comments, while strongly worded, fall within the protections established by this court in Bridges v. California, 1941, she began. In that ruling, the court held that criticism of the judiciary is protected under the First Amendment unless it poses a clear and present danger to the administration of justice. Justice Alito leaned forward. Miss Leavitt, you stated this court ignored 70 years of precedent. That language can be interpreted as suggesting bad faith. I understand the concern, Justice Alito, she said, making direct eye contact. But in New York Times v. Sullivan, this court ruled that robust, even harsh criticism of public officials, including judges, is not only protected but vital in a democracy. My comments addressed legal reasoning, not personal integrity. A murmur rippled through the gallery. Karoline stood her ground, not defensive, only deliberate. Justice Kagan tapped her pen. You're relying heavily on cases involving the press. Your role is different. Respectfully, Justice Kagan in Garrison v. Louisiana, the court extended protection to government officials speaking on matters of public concern. As press secretary, I'm expected to express the administration's views, and my statements were directly tied to a legal policy issue. She moved to the next point. Inwood v. Georgia, a sheriff publicly accused judges of political bias. This court defended his speech, emphasizing that judges must withstand criticism like any other public servant. Justice Thomas, usually quiet, spoke up. Criticism is one thing. Undermining confidence in this institution is another. Karoline nodded. I take that seriously, Your Honor. But in Landmark Communications v. Virginia, the court ruled that injury to a judge's reputation is not enough to silence protected speech. In fact, it stated that the law gives no protection to a judge who tries to shield himself from criticism under the cloak of office. For the first time, the energy in the room shifted. Several justices leaned back, arms crossed, but listening. Behind Karoline, her legal team sat in stunned silence. Even the clerks stopped typing. She turned the page again. My words may have been sharp, she said, voice steady, but they were not reckless. I did not attack the court's legitimacy. I questioned its interpretation. If that distinction is lost, then so is the line between dissent and contempt. Barrett looked down, then back at Karoline. You speak with conviction, Miss Leavitt, but the power of your words also reflects the power of your office. Do you acknowledge the weight that carries? Karoline didn't hesitate. Yes, Justice Barrett, and that's why I chose them carefully. As the chamber fell into an almost sacred silence, Justice Barrett leaned forward and spoke with a tone no longer tinged with reprimand, but recognition. Miss Leavitt, she said, this court will take your arguments under advisement. We will issue our determination within 48 hours. This proceeding is adjourned. With the rap of the gavel, the session ended, but the moment had only just begun. As Karoline Leavitt gathered her papers, a wave of murmurs rippled through the chamber. Clerks, journalists, even the justices themselves seemed shaken, not by anger but awe. What began as a disciplinary hearing had transformed into a masterclass in constitutional law. Outside, the steps of the Supreme Court were blanketed with media. Dozens of microphones extended toward the exit as Karoline appeared, flanked by aides. She paused only briefly and said, I've stated my case out of deep respect for the court and the Constitution. I will refrain from further comment until the court reaches its decision. The press, stunned by her composure, turned their focus elsewhere, for the moment. But by evening, her name dominated headlines. Leavitt shocks Supreme Court with legal defense. From spokesperson to scholar, a star is born on the bench. First Amendment showdown, who really holds the power? In classrooms across America, law professors rushed to include the hearing in their syllabi. Georgetown Law scheduled an emergency panel titled Executive Speech and Judicial Boundaries. Harvard Law hosted a late-night discussion streamed live under the headline Leavitt v. Contempt, a new precedent? Even within the White House, previously skeptical senior staffers now watched replays of her defense with admiration. The president himself, who had once urged her to apologize, called her privately. Karoline, he said, you just redefined what it means to be a public servant. Meanwhile, inside the Supreme Court, the justices gathered behind closed doors. What had started as a potential censure had now opened up serious constitutional questions. Justice Kagan, reportedly impressed, remarked to colleagues, she didn't just challenge us, she reminded us why we do what we do. Justice Thomas, often stoic, was said to have nodded in agreement. And Barrett, who had summoned Leavitt with the intent to discipline, now found herself quoting the young press secretary's exact phrasing during deliberation. Exactly 48 hours later, the court issued its decision. In a unanimous 9-0 ruling, the Supreme Court would not pursue contempt proceedings. Their short statement acknowledged the legal merit and constitutional integrity of Leavitt's argument. Justice Barrett's concurring opinion added, a democracy must be resilient enough to endure critique, even sharp critique, from those entrusted to serve it. Ms. Leavitt's presentation did not weaken this court's authority. It strengthened the national dialogue we are sworn to protect. Karoline Leavitt's composure had not only saved her career, It had sparked a national conversation about free speech, separation of powers, and what it truly means to uphold the Constitution. 6 months later, Leavitt was invited to deliver the keynote address at Notre Dame Law School. Justice Barrett introduced her personally, saying, "Few people have stood before this court as both critic and defender of its principles." Ms. Leavitt reminded us that even institutions must be held accountable, not out of disrespect, but out of reverence for the rule of law. As the auditorium rose in applause, Karoline stood at the podium once more. She wasn't just a press secretary anymore. She was a voice of reason in a divided time, a reminder that even in the face of power, principle still matters.